Welcome to Atlanta Business and Commercial Real Estate Law Podcast.
Welcome back to the Atlanta Business and Commercial Real Estate Law Podcast with attorney Mark Battleson of Battleson Law, LLC. Mark brings over 3 decades of experience across business law, commercial real estate, and deal structuring, with a background that includes both legal work and hands-on business roles. I'm Lisa Mosbey, your host, and today we're talking about commercial lease defaults in Georgia and what business tenants can do when lease problems start becoming more serious. Welcome back, Mark. Thanks for joining me.
Thanks for having me.
Mark, what situations typically put a business tenant in default under a commercial lease, even beyond simply missing rent payments?
I think it's good to understand just what a commercial lease is first. And it is a long-term contract with certainly rent payment conditions, but there's typically a tenant improvement allowance, which is a construction component. A lot of times these are retail-facing businesses, which means there's a pretty heavy insurance component. And then there's a whole series of just rules and regulations and other things that may be in place at a shopping center, office, industrial property, whatever. So as far as payment of rent, that's a monetary default. If you don't pay your rent, okay, you're gonna have a problem, an immediate problem. It's very easy for the landlord to prove that rent hasn't been paid, and then you can be evicted very rapidly. With respect to non-monetary defaults, which is everything else I just talked about. You don't maintain an insurance policy properly. You're breaking rules on the property that causes, either problems for the landlord, expense for the landlord, or problems for your co-tenants, just where you're a nuisance. And then there's a, creditworthiness of the landlord, of the tenant, creditworthiness of a guarantor. All these things can trigger defaults in a lease. So a lease, a typical shopping center lease is 30 to 60 pages long, counting exhibits. These are complex documents. There's a lot of ways to go into default under a commercial lease.
I think one of those big ones that I've noticed is parking lot maintenance, safety, and lighting, all those things that happen in the parking lot. It's not something that you think about, but yet you have some liability for that. Don't you have physical liability for that?
Well, yeah, but if that's more would be the landlord's responsibility and possibly the tenant's responsibility to a third party for public, for safety reasons. So the liability, the parking lot and or just anything like third party liability, like a customer, right? Those are very different, and the lease, has some protections in that for the insurance requirements for both the landlord and the tenant. And you want to be insured to the gills because you don't want to be getting sued and not have a lawyer available through your insurance company. If you get sued through your insurance company and you've got coverage, your insurance company is going to assign you a lawyer, and they're going to deal with the cost of that litigation, which is a huge benefit to insurance that people don't understand. But getting back to your, question is, the landlord may have responsibilities for that, what safety items, just call it that, lighting or otherwise, slip and fall kind of stuff on the common areas. And the tenant shouldn't have liability for that if it is a landlord responsibility, albeit, landlords and tenants get sued all the time together because the third-party ambulance-chasing lawyer, and I say that not pejoratively, but that's just what, they get called. But the personal injury lawyers that are out there, and a lot of them are good at what they do, they are looking to get anybody they can sue. And so this doesn't go to the lease liability, but it's like these external liabilities are just very different to third parties than they are internally based on a contract. One's tort law, which is slip and fall, assault, things like that. And then one is contract law, which is where the lease comes from.
And then after a lease default happens, how much time does a business tenant usually have to fix the problem before the situation escalates?
It's very landlord dependent. And honesty and engagement by the tenant dependent. Sticking your head in the sand is never a good idea. or 99.9% of the time. It is being proactive to let a landlord know, hey, especially if you can't pay rent. If things go bad, in the instance of, you've already started paying rent, and then you can't pay rent because of some issue that's, you're just out of cash. Business isn't going well. It is a heck of a lot better to get in front of that landlord and let them know, hey, look, this is the problem I'm having right now. This is how I'm going to fix this problem. So I'm not a problem in the future. And I need some breathing room in order to get to that. And you better be organized. You better, if you can't handle it yourself, you better hire a lawyer that understands this stuff and how to negotiate it. And keep yourself out of what's called dispossessory process, or which is essentially an eviction. In Georgia, it's just called a dispossessory affidavit in magistrate court, which can handle very large tenant issues, or state court is where larger commercial real estate companies often file suit, just because there's a little bit more controls and better lawyering in those situations. But you can get hit with a dispossessory affidavit from the landlord for non-payment of rent, and you have 7 days in which to answer that. And if your answer is, yeah, I didn't pay rent, but come on, man, just don't kick me out. Well, you're going to have a writ of possession issued against you, because you're going to lose when you acknowledge that you haven't paid rent and you're in default. And then you're going to be forced out by a sheriff within a matter of weeks if you don't cooperate. If you do cooperate, then
Wow.
you get your inventory and furniture, fixtures, and equipment that are yours out of there if there isn't a landlord lien on that. And then you live to fight another day, but you're probably going to get sued and have a judgment against you for any outstanding rent up to the date of a judgment, plus attorney's fees, etc. So it destroys your business. If you lose your place of business, and especially if you're retail facing, you're done. I mean, what are you going to do? You're going to open up a store in your driveway? No. So you better realize paying rent on time keeps the eviction monster away.
Mark, what rights does a landlord typically have once a commercial lease default has occurred? And how quickly can those remedies start affecting the tenant?
Yeah, so eviction through the dispossessory process we just talked about. And then there may be a landlord lien on the property of the assets of the company, which will be filed under what's called a UCC-1 financing statement, but it's a lien on the property of the business, personal property, or it's a leased business. But I mean, technically, you could have, if the business has another location under the same LLC, which I don't recommend, that they own, well, that's an asset, right? So they could go after that if they get a judgment. Then you've got this is a more obscure thing, but it's called a distraint, and it's another form of kind of landlord lien, but it's a lot more aggressive, and it's a more obscure, relatively not often used enforcement process by a landlord. I won't even get into it because it's so rare. Albeit when it does happen, it's an aggressive move of trying to get an injunction and preventing assets from leaving early, and so it happens occasionally with large leases and large assets on those premises. Industrial can be a big thing. Something with some high inventory, and trying to get some enforcement there. And then there's the personal guarantee on this stuff. If you've got liability under the company and then you get evicted, and then the judge gives a judgment of $100,000 on outstanding rent, as well as attorney's fees, et cetera, the guarantor is going to be on the hook for that as well.
You mentioned don't bury your head in the sand. Go have a conversation with your landlord. Let them know what's going on. What kinds of lease workout solutions can business owners explore before the landlord moves towards eviction?
Again, it's landlord by landlord on how aggressive they're going to be. I mean, I've seen some just in the recent past where they've let people accrue deep into the six figures of rent non-payment of rent, and then we try to work it out and settle it. But a smart landlord doesn't wait. I mean, if you're not getting paid rent and the person's not communicating with you, or the tenant's not communicating with you, then you better be aggressive, or it's just every single month that goes by, you have permanently lost rents. I mean, you don't get that money back, especially unless you win a judgment and then collect from the defaulted tenant. So it's better to be aggressive rather than wait 6 months and then accrue a huge, rent liability and then try to collect on it. It's better to try to collect small and then move on to another tenant because you've made a bad decision on this one. But the enforcement speed can be forestalled if you try to get into some kind of a forbearance negotiation where you say, hey, look, I need a break. And here's why I need a break. It isn't just, hey, I can't pay rent and, come on, just, be a nice guy. It better be, here's the problem. And maybe it's even part of a landlord problem. But here's the problem. And I'm having trouble paying rent for whatever reason. And better be specifically identified, not some mealy-mouthed thing. I mean, I get people coming to me all the time, and they just expect to have no accountability. This is an accountability business. It is signing a very complex lease, so you are accountable, and there are defaults and remedies that landlord has. And you want to prevent them from doing that. So how do you do that? Be an adult. Be organized. Be a good business person. Have your ducks in a row before you go and talk to this landlord about your specific problem, about how you're going to fix it, and what you need from the landlord as far as cooperation in order to make up for this lull in your business or downturn, whatever it is, and truly make up for it. They're very likely to not, quote, abate your rent. Abate means they just give you free rent. If they're likely to work with you on what's called a forbearance, which is like, all right, look, we're going to reduce your rent for X number of months, but then you're going to have higher rent in the future and catch up. That's would be the more typical way to do it because they don't want to have permanently lost rents. Again, it's expensive for them. We may be able to negotiate that, but it's just case by case basis, and it's based upon threats of bankruptcy and default sometimes too. I mean, threatening bankruptcy can trigger personal guarantees. So you got to be careful on that. It's called a bad boy act. If you threaten bankruptcy when they're just trying to do their normal enforcement of their agreements, it can cause, it can trigger liabilities beyond what you're exposed to. And that it's more typical on a commercial loan with a bad boy carve out, but on a guarantee. But it can happen in leasing too, and when you threaten bankruptcy or insolvent or state insolvency, then they can accelerate in order to protect their interests.
So, Mark, if keeping the space no longer makes financial sense, what alternatives might allow a business to exit the lease without creating a bigger problem?
Well, if you can get the landlord to terminate early, and maybe with some modest cash payment that's less than the value of the lease, that's one option. I mean, you got to come out of pocket to do that. Typically, they're not unless if you've got a below market lease, like you just signed it 10 years earlier, you got better terms than what's currently available. Your business doesn't meet the landlord's current desire for maybe a higher credit tenant or a different use in the space because maybe he wants a better tenant mix, then maybe you can negotiate your way out of it early because you're below market and the landlord can go out and lease to somebody else at a much higher rate and for a longer term or for higher credit. A high credit tenant is more valuable to a landlord because the lenders and investors value high credit tenants more than they value mom and pops. You just get more money if you're going to sell the shopping center. If you've got Starbucks and corporate stores that have got a lot of cash, that's better than Billy Bob and Mary Sue down as your tenants, who basically are just living hand to mouth, and people will pay more for that for the shopping center. So, when you take a look at like a typical ending of a lease, there's just a process if it matures. But if you're trying to get out early, you got maybe a way to get out of it, especially if you're below market. Long answer to that not being typically the case. The more common is the tenant maybe is out there engaging a broker and trying to get a subtenant. That subtenant cannot just walk into that commercial space, typically without landlord's approval. In which case, the landlord may approve the subtenancy, or the landlord may, which I think is always better, an assignment of the lease so the landlord has a direct relationship with the new tenant, but that doesn't mean that you're getting off that personal guarantee. You can bring in a new tenant, assign that lease to a new tenant, and it's not easy to do, don't get me wrong, especially if you're going to materially change the business there. But if you're going to lose the space, you may want to try to sell the business and then assign the lease. You may want to sell the business and sublet the lease. If you can't sell the business, and then you got to get a tenant in there that's going to do something different, not under your whatever brand you're under, then you again may be able to get a sublease or an assignment of that lease. But typically, unless again you get a Starbucks in there that's got a higher credit and the landlord's happy to be getting rid of the current tenant, you're probably, as the original tenant, going to be on the hook for your personal guarantee, regardless of whether the lease is assigned or subletted in the future. And then just negotiating your way out as a last option of, or just shutting down and moving out. You may be subject to some kind of liens, but you can always shut down and then live with the consequences and try to evade or avoid or deal with them after you've closed down the business. Because it's not just rent that you're paying when you're operating that business. You've got payroll, you've got electricity, you've got all these other things. And if you can't make rent and your revenue is so bad that rent is just one of your problems, then shutting down your business quickly rather than letting it bleed you dry for months or years, it may be better off just to shut it down and live with the consequences. But when you shut it down, you are in default. There are go dark provisions in these leases. If your business goes dark, as in turns off the lights and closes down, you're in default. And because they don't want dark space in a shopping center because it just looks bad. I mean, if you go to a shopping center, you want vibrancy as a customer. So all these ways to exit a lease, they come with, you're threading a needle for one thing. It's not easy to find a replacement tenant that the landlord's going to accept. And if you try to move a subtenant in there without the landlord's permission, get ready to have an eviction process and then a lawsuit from the subtenant if they were unaware of it. And they may be unaware out of blissful ignorance or just being stupid, but you may get sued from a number of people if you just try to sublease without any permission.
Thank you for such important details on this. There are many things that you brought to my attention as well as our audience's attention that we may miss when we're looking at these lease agreements. And having an attorney who's well-versed and very experienced in this is going to save us a lot of pain in the future, financially and personally. Thanks for your time today, Mark.
My pleasure.
That's it for today's episode of the Atlanta Business and Commercial Real Estate Law Podcast. If you're dealing with a commercial lease issue or trying to resolve a lease default before it escalates further, you can visit battlesonlaw.com to connect with Mark. Thank you so much for listening. Be sure to subscribe to the show, and leave a review if you found this episode helpful. And we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.